Legacy Builders, welcome to the second lesson of the copyright chapter of the IP for Business Blueprint course. I'm Jenn McNeely with JWM Designs and Marketing, and in this video lesson, I'm going to go a little bit deeper into the topic of copyrights and how you can transfer your ownership rights for profit. Before we move into this lesson, make sure that you've watched the prior lesson where I discussed copyrights, what they are, what can be copyrighted, and the difference between a registered and unregistered copyright. Why now? Just because you create copyrighted materials, whether it's a photograph, a novel, computer software, video, song, doesn't mean that you are equipped to maximize the potential profits from it. Oftentimes, the best way to take economic advantage of your creative work is to transfer all or part of your ownership rights to someone else. This can be done through assigning or licensing your rights. If you've been thinking about ways to profit from your copyrighted work, before you enter any agreement to assign your rights to anyone else, keep watching. Copyright owners have what is considered a bundle of rights in their creative works that can be transferred in whole or in part to someone else. Those rights include the right to reproduce, distribute, perform, display, or prepare derivative or adaptations of the work. Each of those rights have an economic value associated with them that can allow the copyright owner to profit from the work. Like other forms of personal property, the owner of a copyright can transfer control over the use of the copyright to another person or entity. For example, let's say Jane wrote a children's book and wants to have the book printed and ready for selling in bookstores. Jane does not own a printing company and does not have a distributor network to get the book into stores across the country. What Jane can do is transfer some of her ownership rights in the book to a publishing company for them to reproduce and distribute the book. There are two main ways a copyright owner can transfer their ownership rights. They can assign their rights to someone else, or they can license part of their rights to someone else. Think of your copyrights as a house. You can transfer the whole house to someone else, which is like an assignment, or you can rent one or more rooms in the house, which is similar to a license. Let's talk more about the two types of transfers. Assignment. With an assignment, they typically involve a permanent transfer of the entire copyright, although in some instances, an assignment can involve only a portion of the copyright. When a copyright is assigned to someone else, the rights transferred to the new owner are unconditional, meaning the original owner of the copyright cannot dictate how the new owner may use the newly acquired rights. For example, a freelance designer may assign all of her rights in a particular design to a company that wants to use the design in an ad campaign. An example of an assignment of a portion of rights would be an author who assigns the right to display, reproduce, and distribute a novel to a publisher, but retains the right to create a derivative work, i.e. for rights to create a screenplay or other adaptation of the novel. Licensing. For most of you watching this video, you will likely come in contact with the licensing agreement, which are agreements that give permission for a party to use a copyright under certain conditions and for a specific amount of time. Licensing a copyright can be restricted in several ways, including geographically, by medium, time, purpose, and other reasons. There are two types of licenses. An exclusive license, meaning the right to use the copyright is limited to only the licensee and no one else, or a non-exclusive license, which allows more than one party to exercise the same rights that are transferred in the license agreement. With an exclusive license, it must be in writing, and it means that the person who received the license can use the copyright, assign it to a third party, or sue for infringement. With a non-exclusive license, the copyright owner, who is the licensor, grants permission to another party, the licensee, to share rights in the copyright. This is technically not a transfer since ownership remains with the original author at all times. You cannot sue for infringement or assign your rights to a third party if you have a non-exclusive license. Here's an example of an exclusive license. Jessica writes a children's book in the US, but wants the book published in Europe. So she grants Elizabeth the exclusive license to copy, distribute, and translate the book into French, Italian, Spanish, and Dutch for marketing in several countries. Jessica also wants to market her book to local libraries and bookstores in the US. She then grants an exclusive license to the children's book wholesaler to publish and distribute the book to bookstores and libraries in the US. No one else but the two licensees can distribute the book. Jessica, at the time in which she transferred those rights, cannot distribute those books. An example of a non-exclusive license would be Nikki, who is a software developer, and she created a program for small retailers to track inventory in their products. Nikki can grant multiple licenses to commercial users to use the software for their business. So that means two businesses in the same area can have the same license to the same software. Basic elements of license agreements. While not always required, except in situations of exclusive licenses, writing out the terms of a license agreement is important to protect your ownership rights and to ensure that the party you license your copyright to understands the limits of their authority. Although the term of a license agreement vary depending on how complicated the rights being transferred are, like any contract, there are certain elements that you should always include. Those elements are the name and address of the parties, a recital of the purpose and intent of creating the agreement, the effective date of the agreement, the specific rights being granted, the duration of the agreement, the responsibilities of the parties with respect to the agreement, compensation and/or payment for the use of the copyright, which is also known as royalties, and then other terms and conditions like governing law, the state in which it's going to apply if there's a dispute resolution. You want to know if we're going to go to arbitration or go to trial first, and it just kind of gives us an idea of what's going to happen if there is an issue with the agreement. Also, you need the signatures of all the parties who are making this agreement. Another thing you should do is notarize the document and make several copies of it for your records as well as the records of the person receiving the license. You can file a copy of the transfer with the Copyright Office if you've registered the copyright. To get you started on the road to creating your license agreements, I've included sample license agreements in your e-workbook that you are free to use, modify, and make your own. Remember, your release should be tailored to your needs, and you should always seek additional guidance from an attorney or trusted advisor before signing any agreement. What happens when things go wrong? Most license agreements have specific conditions that must be met by the licensee in order to exercise their rights under the agreement. But what happens if they fail to meet those conditions? As the copyright owner, you have the right to revoke the license. This can be done in writing, and once it's done, if the licensee continues to use your copyright, their actions would constitute copyright infringement. How do I create a license agreement for my business? As I mentioned, each license agreement is unique, and there is no one way to create one. However, there is a general structure for basic licensing agreements, and I've created a basic license template for you to use as a starting point. Keep in mind, the more complicated the rights being transferred, the more likely you will need to seek the advice of an attorney to help you. Why does licensing even matter? As the author of an original work, you can benefit greatly from granting another person or entity the authority to use your copyright. You may not have the network or access to certain markets that another person or entity may have. With licenses, you grant publishers, suppliers, or complementary businesses certain rights to your copyright in exchange for receiving payment or royalty income or much needed publicity while retaining ownership in your copyright. Why not create another stream of income with your creative works? So let's recap. We talked about why a copyright owner may consider transferring their ownership rights for profit through assignment or licensing, the difference between an assignment of rights and a license agreement, the basic elements of a license agreement, and revoking a license agreement. Your action steps for this lesson is to download and review the JWM Basic License Agreement. I want you to take inventory of your copyrights and think of ways that you could potentially transfer some or all of your rights for another stream of income. I hope that you found this second lesson in the copyright chapter to be helpful. We're going to dive a little bit deeper in this topic in the coming lessons. Please post your questions and comments on this video in the comments area below. You can also post questions and comments in the private Facebook group for this course. Remember, you can always find me on Facebook, Instagram, LinkedIn, and my handles to those sites are all listed in the course resources area as well as in your e-notebook. Well, that's it for this lesson, so until I see you in the next video, keep building, y'all.